Is a will better than a trust? It depends on your goals. All a will does is outline how you want your assets to be distributed, appoints a guardian for your minor kids, and appoints an executor of your estate to manage your assets through the probate process to be distributed out to your family. With a will, your assets would be distributed to your family in a lump sum, so you control who the assets go to, not when they go to them. With a revocable trust, you have a couple different benefits here. You avoid the probate process, you get to do incapacity planning, and you get to control the management and distribution of those assets after you pass away. And so in terms of avoiding the probate process, because those assets are not in your personal name, they're in the name of the trust, they will avoid the probate courts when you pass away. With a will, they are still in your name, so they have to go through the probate courts. In terms of incapacity planning, when those assets are inside the revocable trust and you become incapacitated, your backup trustee steps in your role as trustee and takes over the management of the assets inside that trust. That way, you don't have to worry about power of attorneys for the assets inside the trust. In terms of controlling the management and distribution of those assets, for the management side of things, you have two routes that you can think about here, one for your spouse, one for your kids. And so for your spouse, it's likely that you are the one sitting here listening to revocable trust and asset management videos, so it's likely you are the one who is in control of the assets. In the event that you pass away before your surviving spouse and they are near the end of their life, it's likely you don't want them to figure out how to manage the assets that you have passed down to them. So you can keep the assets inside the revocable trust, have your backup trustee manage those assets on behalf of your surviving spouse to take care of them throughout the rest of their life. And then when they pass away, you can distribute those assets out to your kids. When you and your spouse pass away, in both instances, those assets will avoid the probate courts altogether. In terms of managing the assets on behalf of your kids, you can keep the assets inside the revocable trust and not distribute them out to the kids. That way you protect those assets from things like your kids blowing all that money or the assets or their liabilities like divorce settlements, lawsuits, or creditors coming after them, etc. And then when you decide to distribute the assets out to the kids, you can control the distribution of those assets. You could do things like age-based distributions when they turn 20, 25, 30, or event-based distributions when they graduate college, get married, buy the first home, or go into retirement.